Okay, my name is Paul Johnson. I am a tax-paying resident and property owner in Bastrop County, Texas. I am also one of the elected Board of Directors members for the Bastrop Central Appraisal District. This is the first of what I hope to be a series of videos where I will inform the public about policies and practices at the Bastrop Central Appraisal District that seem to be illegal, as they're not in compliance with the property tax code, and in some cases, criminal violations of the property tax code, the Open Meetings Act, and the Penal Code. I found it necessary to use this series of videos to inform the public about what's going on at the Bastrop Central Appraisal District, because the chief appraiser and the other board members have blocked every other avenue of informing the public. They're making concerted efforts to prevent the public from finding out the illegal activities occurring at the appraisal district. I plan to publish each video on YouTube and Rumble. Since this is the first in the series of videos, I plan to cross-post the announcement of this video in other groups that might be interested, but I probably won't go to the trouble of cross-posting the rest of them. So if you found that the announcement of this video in another group and you want to automatically get announcements as future videos are posted, I'll tell you 3 places where I'll be posting them. Okay, this is just a screenshot of my personal Facebook page. I'll be posting them on my personal Facebook page. My name is Paul Johnson. And that's what my page looks like. I'll also be posting them on my ranch Facebook page. My ranch is called Cripple Gray Ranch. And I'll be posting them on a Facebook group that I started called Texas Open Space Appraisals. In order to automatically get future notifications as they're posted, you could friend and or follow my personal page, friend or follow or like my ranch Facebook page, or join my Facebook group, Texas Open Space Appraisals. All the videos, of course, will be posted and searchable later on YouTube and Rumble, so they can be found and viewed at any time by searching those sites. The topic of this first video will be why I'm making these videos to inform the public about what's going on at the Bastrop Central Appraisal District. When I was running for this elected position, I said that my goal was to bring transparency and accountability to the appraisal district. I knew that I would only be one of 9 votes, but I thought if we publicly discussed the policy during an open board meeting, that the other board members would be kind of pressured by just the public's knowledge of the illegal policy, and that they would vote to discuss publicly what they've been doing. And if it was illegal, they would feel pressure that the public also knew it was illegal, so that they would vote to fix the illegal policy. I quickly learned that the rest of the board, at the direction of the chief appraiser, Fawn Cullins, is doing everything in their power, and some things that aren't in their power, to prevent the public from ever even hearing that some of the appraisal district's policies are illegal. If the allegations are never discussed in open session, they think the public doesn't know about them, so they don't feel any public pressure to bring them into compliance. And they can also express that their own ignorance and claim, oh, they didn't know they were illegal. I also think every one of the other board members are respectable and conscientious people. And if they became aware of what the law is, and that we have policies that are against the law, that they would be conscientious and vote to quit their illegal activities. But by following the chief appraiser's guidance, they are preventing anyone from even informing them about what the law is and how their policies violate the law. As long as they just keep their heads under the sand and don't acknowledge that they know we have illegal policies. They just continue to refuse to allow anyone to even inform them that a board policy might be illegal. So here's how things transpired to get to this point. When I ran for election on the issues of transparency and accountability, they recruited their own candidate to run against me. I knew that I would only be one vote out of 9, but I had read the board policy and I saw that any single member could get an item on the agenda. So I knew I would be able to force them to publicly discuss each alleged illegal policy. And then after it was aired out in public, if they voted to continue the illegal activity, their vote and the issue they voted on would also be made public. So I won the election in May, and I was to take office in July. At their June meeting, which was after my election, but before I took office, the previous board changed the rules, specifically to prevent me from ever getting any item on the agenda for public discussion. As you can see, the only single member that can get an item on the agenda is the chairman of the board. The chairman of the board was and still is David Redd. You can also see that for an individual member to get an item on the agenda, they have to ask the chairman to put it on, or at a meeting, ask that it be put on agenda for the next meeting, but there would have to be at least 2 other board members that would agree to allow the item to be discussed publicly at the next meeting. So I took office on July the 1st, and on July the 1st, the day that my term of office began, I sent an email to David Redd, requested that he put an item on the agenda to review the agency rules in the Ag Guidelines Manual. And I included a packet of information with documents that showed their rules, which ones of them were not in compliance with the law, and the laws and cases they conflicted with. David Redd, the board chairman, responded to me that he would not put that item on the agenda, and he acted like it was because I didn't send it to him soon enough, even though I sent it 10 days before the meeting, and the requirement was that I request it only at least 3 days before the meeting. So when the minutes of the first meeting came out, and to skip over a few things, you know, at the first meeting, the item was not on the agenda. But at the end of the meeting, I asked for that item and a couple other items to be on the agenda for the next meeting. And not a single board member agreed to allow any public discussion of that item or of the item of degree of intensity for beekeeping. But they did allow the item of a review of their land classifications. At subsequent meetings, I would ask the board chairman to put an item on the agenda. And since that first request, he hasn't even bothered to respond to my requests. The board has an attorney to give legal advice to the board to make sure the board operates within the law and that all the appraisal district policies and practices are in compliance with the law. So I asked our attorney to give me his legal opinion if the board policy of calculating productivity value for beekeeping without using lease rates was legal. I thought that's what we hired him for. As you can see, he refused to give his legal opinion if a board policy was legal. He gave several excuses that seemed illogical to me, like saying we should get a cheaper lawyer to give an opinion, but he still refused to give his legal opinion. At the second board meeting, I got an item on the agenda about land classifications. Before the meeting, I sent documents about that agenda item to be included in the board members' packets. They did not include my documents in the board members' packets. So I printed them out and handed them out to the board members. Number 10. This is an email from our chief appraiser, Fawn Cullins, to another chief appraiser from a different county, Brent South. However, she was communicating with him as in his capacity as a lobbyist for the Texas Association of Appraisal Districts, which is a taxpayer-funded lobbying organization that lobbies against the interests of taxpayers and also lobbies against transparency and accountability for appraisal districts. The subject of this email from Ms. Cullins to Mr. South was, you can see there, his reply about the subject, Senator Betancourt. Senator Betancourt is the chairman of the Texas Senate Local Governments Committee. Anyhow, in this email, she said that the board members were instructed not to look at the documents that I handed out and not to consider them or discuss them. The documents I was handing out were the law, so they could see exactly what the law said, and other documents showing the facts of what they did that showed that their action and policy were not legal. So I could not get an item on the agenda. I couldn't discuss an item to get other members to see the need to put an item on the agenda. I couldn't get our attorney's opinion if policies were legal. And at each meeting, I would request items to be on the agenda for the next meeting, and for each one, not a single other board member would agree to allow any item to be discussed in public. So the only way I could even notify the board about illegal policies was by making a public comment at the meetings. I did make public comments at a couple board meetings, and later in the meeting would ask for items to be put on the agenda for the next meeting. And still, no one else would agree to allow any topic I mentioned to be discussed at a public meeting. Then, on the day before the December meeting, the lawyer sent me an email saying that he found a case that he claims says board members are not allowed to make public comments at their own board meetings. I didn't have much time to research that case, but even on the face of it, it didn't seem like that's what that case said. And at that December meeting, I signed up to make a public comment, and the board chairman refused to allow me to make a public comment. After that meeting, when I had more time to research that case, I found out, sure enough, the Open Meetings Act does not prohibit a board member from making a public comment. And the case he brought up also does not prohibit a board member from making a public comment. And I told them I was planning to make a public comment at the January meeting. Here's the agenda for the January meeting. When the agenda came out and the documents packets were distributed to the board members, I saw the agenda item saying we were going to be considering and possibly taking action on a resolution about the Open Meetings Act and public comment. There were no documents about this agenda item in the packet, and certainly no resolution, but they passed out a resolution on paper to the board members at the meeting. The proposed agenda item seemed to prohibit a board member from making any public comment at their own board meeting. So even though the board had never discussed this issue, the chief appraiser and the chairman of the board decided that the board of directors finds it to be in the public interest not to allow any public discussion of illegal board policies and practices. And between the two of them, they based that on the court case that the lawyer had sent me the day before the December meeting that does not prohibit a board member from making a public comment. But my first concern about this resolution was that it had never been discussed before, was not included in the packets that came out when the agenda was posted, and it isn't obvious from the way the agenda item is worded to be able to tell exactly what the board was going to be considering about public comments and what the resolution was going to be about. There are lots of cases that prohibit boards from discussing issues at an open board meeting that have not been properly noticed. And this is one of those court cases. In this court case, the agenda item, the way they listed it, seemed to be much more specific than the one on our agenda. But the court ruled that their notice did not provide full and adequate notice, particularly since the subject for discussion was of special interest to the public. And they said that the purpose of the Open Meetings Act is to provide openness at every stage of their deliberations. In our case, the proposed ordinance was not announced ahead of time, so there's no way the public would have known what the agenda item was about. But when they handed out the proposed ordinance, the ordinance itself was contrary to the purpose of the Open Meetings Act because it prevented openness by not allowing the person to let the public know what's going on at the appraisal district. Another case that is cited in the Open Meetings Handbook, they kind of analyzed it and talked about it. And in this case, I'll read the exact wording of the agenda item from that case. It's, quote, "The discussion and consideration of an ordinance authorizing the issuance of the City of Amarillo, Texas Combination Tax and Revenue Notes, Series 2022A, resolving other matters incident and related thereto, including the approval of a paying agent registrar agreement and a purchase contract," end quote. So that was the exact wording of their agenda item. And in that case, the court criticized the city's vague description. And they noted that the notice was patently incorrect and misled the public. And the court concluded the notice did not substantially comply with the act. And so they found that ordinance void. In our case, the wording of the agenda item wasn't so much misleading, but it was so vague, no one could have known ahead of time that the board would be voting to prevent a board member from making a public comment at a board meeting. This is part of the public information, the Open Meetings Act. And the Open Meetings Act does not have any restriction that a board member cannot make a public comment. In fact, it talks about inquiries being made at an open meeting. A public comment is just a comment, but it's possible that during a public comment, they might ask a question of the board, and that would be an inquiry. This section of the Open Meetings Act addresses how the board is allowed to respond to inquiries, which probably occur during public comments. So the Open Meetings Act does not restrict who can make a public comment or who can even make an inquiry. What it does is it restricts the board members from being able to engage in the discussion with the commenter if the topic was not on the agenda. They can only discuss to decide if they should put the item on the agenda for the next meeting. In the Public Information, in the Open Meetings Act, these phrases numbered 1 and 2 are called exceptions. Right there before those numbers, the statute says the notice provisions of this subchapter do not apply to, and then it states number 1 and number 2. So if notice has not been given and there's an inquiry about an item not on the agenda, the board can do number 1, state specific factual information, or number 2, recite the existing policy. Those are the exceptions to the requirement that there can be no discussion about an item that is not on the agenda. But right there in the law, it provides that the public might be making their comment into an inquiry, but it also allows for an inquiry to come from a board member. So not only does the statute not specifically prohibit a board member from making a public comment, it specifically allows for it. But just like a comment from anyone else, the board cannot enter into a discussion or take action on whatever the commenter is commenting about. So to make a long story not quite so long, the board voted to adopt the resolution to prevent a board member, specifically me, from making a public comment at a board meeting. So the chairman of the board refuses to allow any item I suggest to be put on the agenda so it can be publicly discussed in an open meeting. No other members will agree to allow any item I suggest to be put on the agenda to be public discussed in an open meeting. The lawyer refuses to give advice on if any of these policies are legal. And now I can't even make a public comment to inform the public about illegal policies and practices of the appraisal district. So that is why I'm making these videos. Here's a list of some of the topics I plan to make future videos about. The first one is numbered 1, and that is this one, of why I'm informing the public by videos. The others aren't numbered because I haven't decided in what order I'll do them. I want to show you this list so you can get an idea of some of the illegal policies that I plan to inform people about. Whenever I talk about a policy that I believe to be illegal, I plan to show you the actual law that states what they're supposed to do and show the actual documents or other facts to show what they have been. Many of these are written policies that have been illegal as soon as they were written down. And you'll be able to see the written policies and see the law, and you'll be able to see that their policies are not compliant with the law. This list of topics is just what I thought of quickly, and I might add more to the list as I remember others. However, if there's something that you're aware of that is not on this list that you think might be an illegal policy, please let me know. Or if you see something on this list that you really want to let people know about, let me know about so I might prioritize it and put it on sooner than if I don't show such interest in it. Anyhow, this is my attempt to inform the public of illegal policies and practices of Bastrop Central Appraisal District. If you have some interest in finding out about things that are going on at the Bastrop Central Appraisal District, please help me get the word out by sharing these notifications to your own Facebook page, or maybe just to some of your friends and relatives that you think might be interested, so that more people can understand what's going on. Because I don't believe there's anyone else that is willing to tell you what's going on. Other things you can do. Anyone can attend any board of directors meeting. And anyone, except me, can make a public comment at a board meeting. You could let board members know that you would like for the appraisal district's policies to comply with the laws. Or if you believe something is happening in your own case that might not be right, you can file a complaint. Every complaint made to the taxpayer liaison officer has to be reported to the board and will also be reported to the comptroller's office. You can also personally contact the chief appraiser, the taxpayer liaison officer, other employees of the appraisal district, and any or all of the members of the board of directors, even me. And there's my contact information. So the chief appraiser, with the full support of the chairman of the board of directors, is working very hard to prevent the public from finding out about their illegal practices and policies. The best way to deal with governmental agencies that aren't behaving is to bring their misbehavior to light. I'll be trying to bring individual issues that seem to be illegal out in the open for public discussion and proper oversight. Stay tuned for the next episode.